Legal dictation number 118. Be ready. Start. The respondent, who was employed as a teacher under the government of Haryana, claimed advance increments in terms of Punjab government memo dated 1st September 1960. The Director of Secondary Education, Haryana, rejected the claim on the premise that in terms of Rule 10 of the Punjab Education Service Class 3 School Cadre Rules 195, the pay scales of the teachers were subject to variation from time to time, and since the state of Haryana revised the pay scales of various categories of teachers with effect from 1st December 1967, memo dated 1st September 1960 stood superseded. He also observed that higher start of pay with advance increments for postgraduate qualification was provided only to masters or mistresses and not to other categories of teachers. The High Court allowed the writ petitions and directed that the respondent be given advance increments in terms of the Punjab government memo and the letter of the government of Haryana. Aggrieved, the state of Haryana filed the appeal. The teachers employed under the government of Haryana could claim benefit of the higher pay scales, advance increments, etc. in terms of the policy decision taken by the government of undivided Punjab and instructions issued by it only till the revision of their pay scales, which were made effective from 1st December 1967 and not thereafter. The question of revision of pay scales of the teachers employed under the government of Haryana was considered by the Education Commission, which is also known as Kothari Commission. The recommendations made by that commission were accepted by the President of India and were implemented by the state government with effect from 1st December 1967. After revision of the pay scales of various categories of teachers, the government of Haryana issued instructions for grant of monetary benefits in the form of personal pay to those government servants who improved their qualifications by undertaking further studies within the country and abroad. Further, by letter, all the existing instructions were superseded and fresh instructions were issued on the subject. However, the decisions contained in letter and other related communications were withdrawn by the state government by their letter. The High Court erred in accepting the plea of the respondents that revision of the pay scales of teachers with the retrospective date did not result in automatic supersession of the existing policy decisions. Unlike natural calamities that are beyond human control, avoidable disasters resulting from human error or negligence prove more tragic and completely imbalance the intergenerational equity and cause irretrievable damage to the health and environment for generations to come. Such tragedy may occur from pure negligence, contributory negligence, or even failure to take necessary precautions in carrying on certain industrial activities. More often than not, the affected parties have to face avoidable damage and adversity that results from such disasters. the magnitude and extent of adverse impact on the financial soundness, social health, and upbringing of younger generation may have been beyond human expectations. In such situations, and where the laws are silent or are inadequate, the courts have unexceptionally stepped in to bridge the gaps, to provide for appropriate directions and guidelines to ensure that fundamentals of Article 21 of the Constitution of India are not violated. The Bhopal gas tragedy is a glaring example of such imbalances and adverse impacts where by courts' intervention poor and destitute have been provided relief and rehabilitation. The Bhopal gas leak disaster occurred on the intervening night of the 2nd December 1984. Data reflecting the exact number of affected persons was not available initially. Earlier, it was felt that only a small number of persons were adversely affected in terms of health or otherwise by the leakage of toxic gases from the Union Carbide unit at Bhopal. However, the Scientific Commission for Continuing Studies on Effects of Bhopal Gas Leakage on Life Systems released a report titled The Bhopal Gas Disaster Effects on Life Systems in July 1987, which suggested otherwise. This report stated that for the estimated population of 2 lakh exposed to the toxic gases in the severely and moderately affected areas of Bhopal and the variety of long-term problems anticipated in the crisis period, the number of exposures covered so far by the Indian Council for Medical Research through the medical surveys constitute less than 20% of the population. With the passage of time, this figure of the affected population has swollen to nearly 5 lakh. By the same scientific commission, it was also found that in general the output of the medical project so far had not equaled the magnitude of the task assigned to them, presumably due to lack of resources, trained staff as well as physical inputs. This has to be remedied in the shortest time so that project is completed fully.